For this first panel on OTTs, basically the relation between telecom and OTTs, we have a very distinguished panel with two regulators, Gonzalo Ruiz, who is the president of OCIPTEL, the Peruvian regulator. We have also my friend Jefferson, I didn't see you, Jefferson, hi, from the Anatel in Brazil. And both countries have been very active on the net neutrality front, so that's great. Thank you for being with us. We have in the natural role of operators David from Digicel, and who is also in a way today the representative of the Caribbeans, and we have Christian from Entel, and Christian is also as you heard earlier, the chairman of the regulatory committee of GSMA. So Christian and David will present, if you like, the operator's view, and I'm really grateful to my friend Jim Lamoureux from Microsoft, who will basically provide, you know, the argument from the other side of the net neutrality debate. And last but not least, I've got my friend Franco from Telecom Italia, who is the European, if you like, on this panel. I'm also European, but I'm neutral in this. You know, I'm just moderating. So Franco, you are flying the colors of Europe this afternoon. And by way of introducing this panel, I would like to invite Gonzalo to tell us briefly about the recent development in Peru, because I think that would be an excellent way of basically fueling the debate before we start talking about zero rating and specialized services. So Gonzalo, the floor is yours for the latest news on Peru. Do you have the remote? Oh, sorry.
Bueno, muchas gracias, Felipe, están utilizando mi presentación para provocar a la audiencia, así que vamos a procurar hacerlo eficientemente. En primer lugar, agradecer a Cullen por la invitación y darnos la oportunidad de exponer en un foro, digamos, en donde tenemos expertos del sector público y privado, una iniciativa que ha publicado el OCIPTEL el 7 de septiembre relativa a la regulación de la neutralidad de la red en el Perú. Esta es una iniciativa que hoy día está en consulta y justamente la idea es recibir aportes, sugerencias, críticas para poder enriquecerla. Simplemente voy a hacer una muy breve mención a la norma para poder luego pasar al debate. En el año 2012 se aprobó en Perú la ley de banda ancha, que establece una serie de disposiciones relativas a las políticas en el Perú de banda ancha, entre las cuales hay un artículo que menciona que se deberá regular, establecer en el reglamento una regulación respecto a la neutralidad de la red. Este es el artículo que aparece en pantalla, ¿no? Y que básicamente lo que plantea es proteger la libertad de uso de aplicaciones, protocolos y servicios que se brindan en Internet, y establece que el regulador, que es OCIPTEL, es el que debe determinar qué conductas pueden ser consideradas o no arbitrarias. En el año 2013 se publica un reglamento en el cual se regulan de manera más específica qué se entienden por prácticas restrictivas a la neutralidad de la red. No pretendo leerlas todas, pero quisiera que pongamos atención en la 10.2, que dice que en el caso en el que el proveedor de Internet o el operador de telecomunicaciones pretenda implementar acciones basadas en algún argumento que pudieran bloquear, interferir, discriminar, restringir o degradar algún tipo de tráfico, protocolo, servicio o aplicación, digamos, debe contar con una autorización previa del OCIPTEL. Esta es una norma que aprueba el Ministerio de Transportes y Comunicaciones y en virtud de la cual el OCIPTEL debe desarrollar cuáles son aquellos supuestos en los cuales debe intervenir el regulador. Y justamente a partir de esta disposición es que el regulador aprueba el 7 de septiembre, como acabo de decir, un reglamento en donde básicamente consagra dos principios importantes o dos objetivos importantes. El primero de ellos es proteger la libertad de elección, la libertad de decisión del usuario respecto a los servicios que puede acceder a través del Internet. ¿De acuerdo? Ese es el principal objetivo, digamos, que no existan restricciones a la libertad de elección del usuario de Internet. Básicamente, que si es que existe alguna restricción, no se le bloquee el acceso a determinados tipos de servicios, o a través de medidas de administración de la red se distorsione esta libertad de elegir por parte del usuario. Y la segunda objetivo importante es proteger la transparencia o el derecho a la información que tiene el usuario respecto a las medidas de administración de la red que sean necesarias aplicar. Es decir, se reconoce en el reglamento que es posible y necesario en muchos casos aplicar medidas de administración de la red, pero que éstas tienen que ser adecuadamente informadas y tienen que brindarse en un marco de transparencia. Bueno, muy rápidamente, ¿a quiénes se aplica esta norma? Básicamente es a los proveedores de servicios de Internet, a las empresas de telecomunicaciones y también a las empresas denominadas portadoras, ¿no? Esto es lo que nos quiere decir esta... No están incluidos, por lo tanto, en el alcance de esta norma los proveedores de contenidos, digamos, ni tampoco los llamados OTTs. Esta es una norma de neutralidad de red, más no incluye a otros agentes que no sean operadores de telecomunicaciones, proveedores de servicios de Internet o proveedores de servicios portadores. Bueno, y esta es la lámina que estuvo, digamos, que estuvo mientras Philippe hizo su presentación. Muy rápidamente, lo que hemos tratado cuando dijimos, bueno, vamos a regular el tema de neutralidad de la red, ¿qué es lo que necesitamos? Necesitamos una norma que sea relativamente sencilla, simple, y que establezca procedimientos que a la vez que sean simples y rápidos, sean predecibles. Y lo que hemos tratado, digamos, para buscar esa predictibilidad, es establecer en qué supuestos vamos a adoptar determinado tipo de tratamiento. ¿Qué tratamiento le vamos a dar a cada tipo de práctica denominada de administración de red o que pudiera ser considerada, digamos, que podría afectar la libertad de decisión de los usuarios? Y como vemos acá tenemos tres categorías. En la primera parte tenemos las prácticas consideradas arbitrarias. En la segunda tenemos las prácticas que podrían ser bajo ciertas condiciones consideradas arbitrarias y que por lo tanto requieren una evaluación. ¿No? Hay tres prácticas en donde hemos reconocido de que no existe el blanco y el negro. Depende mucho de la evaluación de las circunstancias en las que se den los mercados para poder determinar en qué medida hay una afectación o no a la libertad de elección. Y por último, algunas prácticas que simplemente tienen un deber de ser notificadas, que están permitidas. Simplemente lo que establece el reglamento es que sean notificadas o informadas al regulador y a los usuarios. Muy rápidamente, porque quiero darle la libertad al panel. En las prácticas arbitrarias están incluidas las de manejos del ancho de banda, ¿no? Lo que es el manejo de ancho de banda, que no estén incluidas en las excepciones que voy a mencionar acá abajo, o lo que es las medidas de bloqueo o filtro de servicios o aplicaciones. También que no estén incluidas dentro de las excepciones que están abajo. En la práctica, digamos, esta primera categoría son prácticas que a priori están prohibidas. Sin perjuicio de ello, el reglamento establece que excepcionalmente podrían ser evaluadas y aprobadas por el regulador, ¿no? Pero en principio son medidas prohibidas. El segundo tramo, que son aquellas medidas consideradas, digamos, que requieren una evaluación previa, están incluidas la diferenciación por el diseño comercial del producto, que acá están las famosas zero rating u otras del mismo tipo, medidas de manejo de direcciones IP o de duración de la sesión dinámica de la red. Y en este caso, digamos, se establece un periodo de evaluación de 20 días para el pronunciamiento del regulador. También se establece que en caso que se trate de medidas que hayan tenido un pronunciamiento previo por parte del regulador, medidas que puedan ser similares, simplemente hay un procedimiento de adecuación automática, es decir, no se requiere, digamos, un pronunciamiento o esperar el pronunciamiento del regulador, sino que hay un proceso de adecuación inmediata. Este es uno de los temas quizás más discutidos o más, porque en muchos casos algunas empresas han planteado que esto le puede restar flexibilidad al proceso de ofertas en el mercado. Esto quizás sea un tema para discutir. Y más abajo tenemos las prácticas que no requieren autorización previa, por ejemplo, aquellas que, digamos, son prácticas que obedecen a una orden de un juez, o prácticas en situación de emergencia, cuando hay un problema de congestión o un problema de interrupción, cómo se puede priorizar el tráfico justamente para que pueda, digamos, hacerse un uso eficiente en situaciones excepcionales de emergencia, y también las llamadas prácticas no arbitrarias, como por ejemplo prácticas vinculadas con el bloqueo o filtro de servicios a pedido del usuario, ¿no? El usuario puede solicitar que sean bloqueados determinados tipos de contenidos, ¿no? Digamos que como parte de su servicio. El uso de Content Delivery Networks o prácticas en cumplimiento de obligaciones contractuales asumidas por el Estado. Este es un poco el panorama de lo que se está planteando en el reglamento. Son tratamientos diferentes en función a los riesgos potenciales que se han identificado en determinado tipo de medidas. Y eso es lo que se está presentando, evidentemente es un resumen, pero grosso modo es la propuesta que ha planteado el OCIPTEL y que esperamos pues que promueva, digamos, una mayor transparencia en el mercado, ¿no? Lo que queremos es, no queremos que esta norma sea un obstáculo para la innovación, un obstáculo para la competencia, sino todo lo contrario, que haya mayor transparencia, mayor confianza en las distintas prácticas que se dan en el mercado, sobre todo de parte de los usuarios. Con esto, Felipe, muchas gracias. Termino mi intervención.
This one works. Thank you, Gonzalo. Thank you very much, Gonzalo, for this introduction. And may I say that I love when legal matters are presented in the form of algorithm. I think for non-lawyers it makes things seemingly clearer. Maybe not for you, Christian, but also I think, okay, so we have the support of lawyers here on the panel. Thank you, Gonzalo, for this extremely clear, I think, presentation of the intention in Peru, and I think that it resonates with the kind of debate that happens in all countries. So I think it's beyond the Peruvian view of things. I think it's pretty generic. It's a pretty generic algorithm that could apply to many countries that you have presented there. And I was thinking for this panel to perhaps have something rather interactive where we structure the debate along the big issues, you know. Historically, the biggest issue in net neutrality was the blocking of Skype, for example, Jim, the blocking of voice over IP services. I think that in Europe, in most countries, this is a bit an issue of the past, but we have the privilege to have David here from Digicel in the Caribbean. And perhaps, David, could you, before we move to the other topics, like specialized services and zero rating, give us a bit the view in the Caribbean from the state of regulation, first of all, and your views on the blocking of application by mobile operators.
Thank you, and good afternoon, everybody. As Philippe said, we are an operator in the Caribbean, and we operate out of Jamaica and most of the other islands in the Caribbean. I would love to have had a presentation today to show you photographs of all of those islands, and we could have had a nice talk about them. But I was told that perhaps it's better to have a conversation without presentation. So the issue of blocking is very topical in the Caribbean at the moment, and there's a number of reasons for this. Firstly, these are developing markets where investment in future broadband networks is something that's very, very important. Secondly, the regulatory regime is probably not quite as modern as you might find in the European Union, so you still are looking at a licensing regime, and specific services like voice services need to have a license. So this has led to a very interesting debate, as you can imagine, as VoIP apps became more prevalent, and this is something that's a sort of a recent feature as well, because smartphone penetration is increasing and broadband networks are being rolled out. So we've had a very lively debate over the last year and a half. This began with the VoIP apps, and basically all operators took the position of blocking VoIP apps in the beginning on the basis that these were services that clearly required licensing under the legislation, and no steps had been taken to apply for licenses and so on. This debate, as you can imagine, didn't go anywhere very fast, because you're dealing with a number of different jurisdictions that had different approaches. Some absolutely supported our position, and you're talking about, you know, revenues of operators in the region being more or less 70% reliant on voice, and of that, about 20% being reliant on incoming international calls. So, you know, had the market switched to VoIP apps immediately, you would have been talking about the telecom operators simply going out of business. On the other hand, there was a lot of consumer demand, and some markets, you know, the regulators absolutely did not favour the blocking of apps, and frankly weren't that interested in discussing the issue. So we had a bit of a conflict. It's, you know, I think consumers, you know, the consumer's choice really is what dictated the actions of operators, and you know, operators are moving to provide access to VoIP apps in bundles, you know, as we've seen in European countries and elsewhere. But I think perhaps the more interesting debate, because that, in my mind, that was, you know, very much predicated on the fact that these were services that were identified in legislation as requiring license. But I think it's probably better to keep this as in our minds as a separate and very kind of distinct issue, and look more specifically then about, you know, what is happening in the value chain, you know, what sort of services are being offered, by whom, and where do net neutrality rules fit in this debate. And the danger we have, I think, is that if we put in place stringent net neutrality rules, we're in danger of picking winners and losers in what is, you know, an evolving and developing market. And I mean, simply put, you know, who said that the only people who are allowed to monetize using the internet have to be based in Silicon Valley? Who says, look, why is it that network operators can't be part of the value chain? So what we've done as an operator recently, and you may have read about this in the media, is over the past few weeks we've become the first operator to introduce ad blocking at the network level. And, you know, our strategy is twofold. One is that, I mean, I think even, you know, if you look at quotes from people who represent the online ad industry, you know, that industry, by their own admission, has run amok and is quite out of control, much to the disadvantage of consumers. So we have a consumer problem. You know, consumers' data has been used up. People are getting, you know, increasingly annoyed with, you know, more and more ads and so on. But that's one side of the argument, and it's important to protect consumers. And then, of course, we have the question of the value chain. Where do operators fit into this value chain? Is it correct that, you know, the online ad industry or content providers can say, no, operators, you're not allowed in the value chain, and we're going to monetize this whatever way we like? Are operators allowed to at least attempt to come to some sort of settlement with others in the value chain and to assert their right to a place in the value chain? And our view is that operators are very entitled to do that. Now, just to finish, if it is the case, of course, that the market sides with us, then clearly the market has decided. If others in the value chain decide they don't deal with us, then perhaps we're looking at a question of market power. But certainly our view is that, you know, there are commercial discussions that are relevant to many parts of the value chain, and what we don't want to do is introduce regulatory rules that pick winners and losers.
Thank you. I will ask in a second the two operators on the podium who live in countries where blocking apps is something of the past, whether they regret it or whether they've learned to adjust their business model and to have more data-centric models. But a quick information for you, David. In France, 2-3 years ago, one of the major operators blocked advertising. And it was quickly told by French authorities not to block advertising because a company like Google, for example, if my memory serves me well, in 2012 spent $7 billion remunerating bloggers that write blogs on Argentine footballs or wine or whatever, Ezekiel, around the world. So basically, the French ministry told the French operators to stop blocking ads, not because they like Google. Jim would say they may not like Google very much, but because they wanted to protect French bloggers and continue to have the flow of checks coming from Silicon Valley, basically. Now, Christian, what is the view from Chile and basically from GSMA Latin America on the fact that you can no longer stop application? Have you learned to live with that?
Really, we don't have a trouble with that because, Philippe, let me very shortly explain you our experience in Chile. As you know, Chile was one of the first countries worldwide to regulate neutrality by a law, by a parliament. And I would say that the good approach of this law, it was a very general principle law, established the typical 3 principles that we all know, established some restriction in terms of course, you cannot block, you cannot throttling, you have to have transparency, you have to make prioritization, but always it leaves the operators to manage the network in terms that you are not going to affect competition, you're not going to be capricious, you're not going to be arbitrary. Huh? So our experience is that at the end, it's a good approach. You have this general law in terms that has been the regulator, the one that has been interpreting the law by case law, by resolutions, but you have a general frame. And the good thing of this, of having this flexible and open approach and leaving the operators to manage the networks, is that we think it's the only way that you can foster innovation, that you're going to really foster investments, that you're really going to deploy the market, the industry, the customers. But the main thing is that you're in an environment of competition. Of course, the main issue here is that you are in a competition environment. And the good thing of this is that we think it's the only way to have this flexible approach, is the only way you're going to be able as operator to make differentiation by 2 ways. One is going to be a tariff innovation, for example, and there you can have for example applications-based tariffs. For example, if you have a customer that really wants to be the whole day in Facebook, and it's the only thing that really he wants to do, it's his option. And the good thing is that you can give him a lower price because you're not giving him all the services.
Yeah, we'll talk about that in a minute.
Also another tariff innovation, zero-rate services. And by the other side, the other good thing that you can do is to give specialized services in terms of healthcare, and we know that you have to give a priority to those services because...
That will be a major topic. Franco, quickly on your experience at Telecom Italia in not being able to block. Have you forgotten about that, or is it something that you regret?
No. In Telecom Italia, we are following the new rule that is coming from Europe. It's a recent rule that blocked totally the possibility to block the traffic.
And maybe to ask Jim, Microsoft is the owner of Sky for a few years now. What is the trend around the world? Is it the end of your troubles, or are there still some parts of the world? Because we know about Latin America, we know about Europe, the US. I have no idea what's going on in Asia, in Africa. Is it?
We have not had any problems in the US for quite some time with blocking or degrading or throttling of Skype or other VoIP traffic. In Europe, we still had some problems up until maybe a year or 2 ago, but the problems have been on a downward trend as the operators sort of, I think, saw the writing on the wall that the net neutrality rules were likely to be implemented. We still have some problems in the Caribbean. We are in some, I don't know very recently if VoIP is still blocked. I haven't paid attention. No block that stopped, okay. We do have some problems still in Asia. There are still, particularly not so much on the voice side, but on the messaging side. There are still some countries in Asia where the regulators have actually endorsed the idea of blocking some over-the-top messaging services to essentially protect some of the incumbent messaging revenues there. On the whole, though, I would say that globally, our issues around blocking have been declining over the last several years.
Thank you, Jim. Jefferson, may I perhaps ask you to introduce another major topic for this panel, which is specialized services. What is all the fuss about, and what is the Brazilian view on that?
Thank you, Philippe. Well, first to say that I'm here speaking my personal view, since Anatel has not decided on some words on the regulation. Actually, Anatel made a public consultation on the Article 9 of the Internet Civil Rights Framework that was approved last year in Brazil. And this is up to Anatel and the Internet Steering Committee to provide to the presidency their views, and the presidency is in charge to regulate the Article 9 where we have these net neutrality rules in the Brazilian law. So, well, I think this is the most complicated issue that we have in the law. Net neutrality, zero rating, specialized services. Every time we try to find answers to these questions, we find more questions than answers to them. So, and especially with zero rating and specialized services. Well, I'd like to remember FCC. They spent many years discussing net neutrality, and after many pages of the order, at the end they just left specialized services and zero rating to be decided in a case-by-case basis. So I think maybe all the regulators will follow this trend, since it's quite complicated to decide if zero rating is allowed or not, what is exactly specialized services. But my view, and that's again, it's very personal, I tend to believe that if specialized services is totally approved, allowed, we may tend to be focused, the networks, investments in networks and services tend to be focused on specialized routes, and hence devaluing the public internet network. So this may not be good for people that are not covered by these specialized services. And then a possible way for regulators would be to approve it, to approve zero rating specialized services in a promotional basis and keep track in the ISP's behavior. But again, that would be quite difficult, because it will demand from regulators to invest a lot in enforcement, which is obviously much more complicated in the internet and data behavior than. Well, and final words would be this idea of a pure net neutrality, treating all traffics equal, opposes to the idea of smart networking. I think this is quite complicated, and something that a commissioner in Anatel told us before coming to this debate is people tend, and especially the OTT, tend to say that, okay, yeah, you are just a dumb network and the smart is in the edge. And I think it's not true put in this way, since both services need smart networks to work. So this is another discussion.
Thank you. I would like, because in order to steer a bit the debate, David, it's good to have, and I thank you for the first question. You were the one disagreeing with the rest, so that's good. And I would like to invite as a speaker the one who is perhaps a disagreeing voice on this panel, and I know Jim, and I know that Microsoft doesn't support the view that specialized services are needed to provide the health services, the e-health services that Christian mentioned, or other sexy application. And Jim, could you explain what Microsoft have against the emergence of these? Surely you don't want your pacemaker monitoring to be mixed with kids downloading movies, you know?
Well,
no, here.
Thank you. I think the first point is that, often Microsoft and other cloud services providers are portrayed as the opponents to all of the network operators. And I want to dispel that idea first a little bit. We also believe that there needs to be incentives for investment and innovation in the connectivity layer, because as a cloud services provider, without connectivity, none of our services work. Connectivity is the oxygen for all of our cloud services. So we're just as concerned about making sure that there's plenty of room for innovation and investment by all of the network operators in provision of internet access and connectivity. And we sympathize and support with their, all the network operators' search for more ways to innovate and invest. On the idea specifically of specialized services, I would say we're not opposed to the network operators, the ISPs, coming up with their own new services that are based on or tethered to their own networks. I mean, that's something that the network operators have done for centuries. They have networks and they come up with new services that they themselves offer over their networks. Started with voice. As we moved into an IP world, many of the telcos branched out into providing IP-based television services on their networks. In the US, some of the telcos now also provide home security services over their own networks. We're not opposed to the network operators.
Jim, if I may interrupt you.
Sure.
I mean, Jim is a former AT&T, so he knows both worlds, frankly. Between us, telcos are not the most innovative companies. They will never develop these verticals. You know, they are good at running networks. So saying you can do it, but for your own application is just like saying don't do it. You know. Now, let's go back to the social needs. Society, I'm trying to think. You know, road traffic management, e-health, help me with more sexy application. There must be a way to secure for society high quality connection. Are you really opposed of Microsoft to that?
All right, so you're going to force me to say the things that we disagree with. First off, I'm not going to sit in a room full of operators and regulators and say that operators are really bad at providing services.
I said it, you don't have to say it.
My concern is that if you go down the path of allowing operators to enter into deals or arrangements with third parties to provide those third-party specialized services over the network operators' networks. To me, that sounds very close to the idea of allowing fast lanes on the network operators' networks for whoever they want to go out and cut a deal with. And that is the heart of the net neutrality debate. It allows the network operators to pick and choose who they make deals with. It potentially allows for the possibility of discriminatory treatment of some third parties over others. It creates the possibility of the operators essentially having a tax on innovation by charging for that. And then my last concern is, you said, you know, societal interest, everybody would agree that allowing driverless cars or telemedicine is in society's best interest. But I think you've picked the two obvious examples. Mm-hmm. And when you get sort of more towards the middle, I think there's a huge difficulty in who decides that some specialized services are in society's interests and some specialized services are not in society's interests. Mm-hmm. If I'm a 17-year-old kid and I love to play Halo on my Xbox, to me the most important service I can access is online gaming, and I don't care about voice and I don't care about video, and I probably don't care about telemedicine all that much, frankly, because I'm a 17-year-old kid and I'm going to live forever. So who gets to pick and choose which societal services are the ones that are allowed to be prioritized and which ones aren't? I think that creates a huge problem.
Gonzalo, we heard your algorithm presentation, but what is your own view? Should specialized services be banned, as Jim suggests, or should they be allowed under a close supervision from OTTs? Also bearing in mind Jefferson's comment, which, if I may paraphrase you, Jefferson, you said, you know, specialized services are maybe fine, but then are telcos still going to invest into basic access to internet, you know? Because if you can sell fast lane, are you still interested in selling not slow lane, but normal lanes? How do you deal with that?
It's a difficult question, but I think that the principle is, or the main question is, who is empowered, who is the one who have to choose or to pick and choose which content or which services has to be in the fast lane and which not. I think this is the most important question. Neutrality, net neutrality regulation seeks to ensure that the consumer is entitled to the power to decide what is the content they want to choose, not the operator or a third party. That's I think the most important part of the debate of the question. In some cases, some kind of application, some kind of content or some kind of service you need to deliver, obviously may demand some broadband speed and demand some characteristics, and how to ensure that these coexist with a framework in which consumer can decide what is the most convenient for their interests. I think that is the most important. This is the big question there, and it is the central question in net neutrality.
Thank you, Gonzalo. David, from the interested side, what argument would you have to oppose to Jim to this ban on specialized services? Do you see at least extreme scenarios where they should be allowed?
Thank you. Well, say is nobody is saying that operators want to censor the internet or block people's access to information on the internet. So that's not what the debate is about. But you know, we have a situation. I mean, let's look at it this way: is there a problem to be fixed to start with? What's the problem? You know, we have competing operators, you know, all competing to provide the best services they can to consumers and to businesses. And, you know, is there a need for market intervention here at all? I would argue there isn't. Operators are going to do their best to sell their services no matter what. And let's look at examples in other industries. You know, we look at electricity. Yes, there's a different rate depending if you want to sit with the light on your sitting room or whether you're running a steel factory. Or there's a different amount of water if you have a swimming pool or if you just want a glass of water in the kitchen. So why wouldn't operators be free to commercialise, you know, their property as best they can? And I think this is probably in the best interest of consumers, because if operators can, you know, charge a wholesale rate to bigger users, and let's be honest, it isn't just a question of what consumers want, it's about how much these big users want to put down the pipe as well. But if we can charge different rates and provide different services depending on requirements, this could end up very good for consumers, because they could end up with services that are either, you know, better quality or lower price as well.
Thank you. Perhaps a note of caution of you, if I may, on your confidence in the level of competition in the industry, because frankly, there was really a lot of competition in the telecom industry. I'm not sure that regulators would have had to come up with a net neutrality rules on no blocking of application. Market forces would have led to no operators daring to block for fear of losing customers. But that's So Christian, what are on specialized services?
Well, I think I always return to the main rule: competition and more competition. If the market is asking for those services, and those services for the nature, for example, in case of healthcare, you say it's very clear that you cannot compare a health service, care service with an entertainment service. Of course, you have to give priority to those services, because if not, it's not gonna get the goal that it's for that provision. So you need to assure that. An important thing is that nobody's talking here that you're going to discriminate someone. The important thing is that you are going to be allowed to give those kinds of services. The important thing is that you have to give it under non-discrimination basis. And you can't do that. And the important thing is that competition has to do its role. And it's the only way how you are going to really develop the market and also to assure the interests of the customers. And by the other side, there's a very important thing that we haven't said here, that we have to remember that when we are talking about mobile networks, that I would say there we're going to have, net neutrality is going to be is more relevant how we regulate neutrality in mobile networks and fixed networks, because we all know that in mobile networks we are sharing the resources of the network. We all are competing for the resources. So nobody can assure or guarantee a certain quality to that network. So it's really very clear that as an operator you have to manage the network. And all the operators manage the network. If someone here is saying that they don't manage it, it's not true. The important thing is that you have to manage it under non-discriminatory basis, not against antitrust law. You have to be fair, you have to be not capricious, you don't have to give benefits to your related companies or providers. But the important thing is that we have to believe in the market and the competition of the operators. If you have a problem in that market where you have really a dominant operator and he is doing bad conduct or against antitrust, well, then all the system that you have, the regulator and the trade institutions have to act.
I want just to add that.
Yeah, and what I would like, Franco, say what you want, and then tell us a bit if you are up to speed with preliminary contact, perhaps at this stage, between Telecom Italia and AGCOM, the Italian regulator, in terms of how do we implement, the supervision by the Italian regulator of presumably tomorrow the provision of specialized services by Telecom Italia that is made possible by the new EU regulation.
This is a very hot topic because, of course, this new regulation demands to the national regulatory authority the possibility to monitor the enforcement of the new regulation. So it has been given, in my opinion, a very wise open door, so that case by case these specialized services will be allowed, and how. Because to decide at a very top level immediately would have been...
Now, let me ask you an awful question, Franco. We're good friends, so between friends we can be really awful sometimes. I said earlier something, I had forgotten you were in the room. I thought there were no Italians except my colleagues. So I said something terrible about Telecom Italia not investing in NGA, unlike Portugal Telecom and the others in Portugal. Now, so Telecom Italia, for a reason that we all understand, has not been the champion of investment in NGA. Now you're going to make money with specialized services. I think in your case, I'm a bit with Jim, Is Telecom Italia, you're going to have even less investment to invest into your normal network if you can sell fastly. So what do you answer to that?
We are changing our direction, trying to invest much more recently. We have a great plan to upgrade our network, and there is a decision. Italy was divided in three type of regions. One are the regions which are of market failure, and in that case there is a subsidy from the state. Yeah. Then there are regions in which there is already one operator, and so it doesn't need maybe support, but it's a discretion in that case, and the area which are already developed, and so there is no need of an increment of
Thank you, Franco. Let's move now to the next topic, but while we do that, I don't want to have a monopoly on questions. Think in the room of questions. I say Andres is ready. Do you want to ask one on specialized services before we go to zero rating? Or is it? Okay, I'll hand you the microphone. So Andres Mann for Cisco.
Thank you, Philippe. Yesterday, preparing the comments we filed today during OCTEL consultation, I was looking into the number of apps that were created every day. So just on Apple, 1,000 apps are submitted every day. In addition to that, we have, we predict between the 20 to 40 billion devices that will be connected to the network. Each application, each device will have different requirements, network requirements to work and be able to do what it's supposed to do. And yet we are envisioning a framework in some cases where we can go, look, decide, make decisions. I don't see how one body, regardless of the country, can look and try to have a view into what could be permitted, what could not be permitted. No, without smart networks and without the intelligence to be able to enable all of this, it seems impossible to me that we can use ex-ante regulation to create the environment we want.
You have a question addressed. Do you want to talk about specialized services before? Can you keep it for a sec, and then no more question on specialized services or comments? No? So who wants to react to Andres? Jim? Yeah.
Well,
yeah, you've got a microphone. That's great.
I think one concern I would have is each one of those 1,000 apps could make a claim that in order for that app to work, it needs some sort of optimization on an operator's network. If I'm a travel app, I could argue that I need optimization in order for my transaction to work correctly. If I'm a voice over IP app, I need optimization in order for my voice traffic to work correctly. Every one of those apps could make some claim that I need optimization on the network. And what that could lead to is, frankly, the over-the-top operators, providers like Google or Microsoft who have lots of money to be able to pay for optimized treatment of all of our apps, and to the detriment of all of the very small network or over-the-top providers who don't have the capital to be able to. And so that's the concern about leading to not discriminatory access, but discriminatory outcomes, in that it allows those with the capital and the resources to be able to pay for that optimized treatment, and the smaller over-the-top providers get left out because they don't get optimized treatment because they can't afford to pay for it. I think that's the concern, and that's what led to the EU and the US adopting rules against essentially fast lanes on the internet.
So, yes.
I think we may disagree depending on which provision of the regulations you look at.
Yeah. Gonzalo?
Yes, well, if I understood your question, the regulation we propose only applies to network operators, not to OTTs or applications, to the extent that applications are not related with a plan or an offer to the consumers, to the final consumers. Let's say zero rating plans or other offer similar to zero rating plans. So the extent of regulation only focus in traffic or bandwidth administration, not on design of applications, on other kind. It would be impossible, I agree with you, to analyze and to evaluate the requirements of each application, the network requirements on each application. The regulation only focuses on network operators, only to telecom and network operators. Our regulation, our proposal.
Thank you, Gonzalo. I think we should move to the next hot topic, and there will be other topics. Or do you want to ask a question? Okay, please. Oh, you need to push the button here and hit the light. No.
Hello, yes, it's working. Okay, my question is to Jefferson from Anatel. Okay, 1 week ago in Futurecom, your colleague from Anatel in the main panel said that the war between OTT and operator is not regulator war decision, and that the market will do that. Do you think so?
Well, I think that the tendency is that for the discussion on net neutrality, zero rating specialized services market can offer the best possible answer for this relation. And I think that it's quite difficult for the regulators to assess the environment right now. So it's quite new. The Brazilian market, for instance, we are one year, not more than 1 year, assessing and having zero rating plans. So it's a quite new plan for the regulator to evaluate if it's damaging or not the market. So I think that the best way for regulators right now, and the new is quite low as well. It's quite new as well. So would be better for regulators to wait and see if it's damaging the market.
Thank you, Jefferson. Let's now move to the other hot topic that is make the front page of newspapers. It's this zero rating. And maybe Jefferson, do you want to introduce the topic and tell us what this is about?
Yes, well, we have identified in the agency's public consultation at least 3 main practices of zero rating. The first one would be this classical zero rating, everyone knows that. It's when the ISP selects an application and the user is not charged for the traffic user to access this kind of information coming from that application. The second one would be when the ISP provides free access to a bunch of applications considered of public interest or a not-for-profit service. And the third would be these sponsored services or sponsored access, in which the content provider pays the ISP, pays the telco, for the user's access. This is clearly with some government or banking applications. It's been quite common, especially in Brazil. And then we ask if what the society would think it's allowed or not, if something should be reformed. But again, and this is important when Jim said regarding who decides on what is societal best interest and what is the public interest, and would be very difficult. That's why the market may be important to evaluate, for regulators to evaluate. And some people can say that zero rating can shape the market to the detriment of consumers' choice. Well, that may be true, but again, if you have competition and you have awareness in the consumers of what they are buying or in which networks they are, I think that this can be a kind of irrelevant assumption. But maybe in the future, I think that zero rating and alliances among different OTTs and different ISPs will create clubs of contents. And then, just like all the industries, you have to choose, okay, I can go to network A, and in this network A, I will have different contents, and maybe all this content is in my interest, or I can go to a network B with different contents. We can see this, for instance, in the health system. When you buy a different health plan, you have some hospitals and some clinics, but you don't have in another plan. So you can find many examples in other industries, in other economic sectors. So I don't think why telecommunication operators and telecommunications industry could be different from that.
On zero rating, do you want Gonzalo to say something? Is it something that is?
No, I agree with Jefferson that zero rating is a topic very difficult because it depends of the structure of the market, the relative impact of a practice of a zero rating or a similar nature of zero rating practice, it depends of the structure of the market. It's not the same when you talk about a very highly concentrated market in which zero rating could be a source of not a source of limitation of the consumer rights to choose, than in the case in which you have a competitive market in which zero rating is a tool of competition. It's a strategy to compete. I can say, for example, in Peru, the zero rating are part of the game of a competition. I recognize that, but I don't know if in the future could be different if you in a context in which there are not the same alternatives to choose for the consumers. So that's why in our proposal we establish a case-by-case analysis, because it's not black or white. It depends of the market structure. I think that the analysis of the impact of this kind of measures, it will require to see the data and to evaluate what is happening in the market.
Thank you, Gonzalo. This is also, as you know, the position in Europe. There is no outright ban of zero rating, but so Jim, you are the dissenting voice on this panel, and you feel a bit alone, so I will help you a bit by saying that in the run-up to the adoption of the European regulation, the European Association of Consumers was lobbying very strongly against zero rating, which I found a bit paradoxical. I thought that would be good for consumers, but so Jim, you probably have a point, because European consumers agree with you, apparently. So why is it you don't like zero rating?
Well, I think...
Your friend from Facebook love it.
Well, my friends from Facebook like internet.org, which allows you to get a version of Facebook, not the internet. So I think Facebook has some selfish reasons for promoting internet.org, which is not necessarily the same as zero rating. And I don't know if there's anybody from Facebook here, so I'll stop bashing Facebook. I think there are two potential concerns that we see with zero rating. The first is that zero rating has value mainly because of data caps. If there were no data caps, then zero rating really wouldn't be of value to consumers, because the primary way that zero rating is used is once there's a data cap established, the ISP can then give consumers access to some content and services that don't count against the data caps. And so if you allow a world in which zero rating has no restrictions and is allowed totally, there's a concern that it could allow the operators to focus, rather than innovating on their network, innovating in how they establish data caps and innovating in how they make money off of allowing zero rating of the data caps. And again, we would prefer that there is a focus on innovation and investment in connectivity, not innovation in tariffing practices. The second possible concern we see is that at some level there is the possibility of the same harm with zero rating as there is with fast lanes on the internet, which is if ISPs can charge online providers some amount of money for the ability that their content and services doesn't count against the data cap, that essentially is a innovation tax at some level that the online providers have to pay to the ISPs, and it allows for the possibility of discriminatory outcomes. But I want to conclude with one thing. There's no common definition of what zero rating is. There are all sorts of practices that could be out there. And in some level, zero rating could be beneficial. If you allowed all consumers to access every regulatory website in the world, and that didn't count against your data cap, I think everybody in this room would think that's a great idea. And so because of that, we agree with Gonzalo and with what the FCC did in that rather than have ex ante rules prohibiting something that's not very well defined yet, looking at zero rating on a case-by-case basis as it's implemented to determine if in a particular case it's maybe contrary to the market.
Yeah. Yeah, thank you, Jim, and thank you for coming closer to the consensus around this. We are forging consensus in this symposium.